Might be a good time to remind you,
Read
it is
each
your,
one of them aloud? Is that what
your
we're doing?
policy manual.
Reading these aloud? I don't think so.
Yeah.
I hope that's not what we're
Yes. That is what we're going to do. Line by line by
Cover to
line.
cover.
Yeah. Perfect. So, good afternoon. We'll officially start our first policy review workshop today. I know that we have two board members that were unable to make it, although I'm seeing one that I thought wasn't going to be able to, but we still have a quorum. So this is the first time that we've done this, essentially, and I know, Mrs. Goodwin, you just mentioned how do we want to go about it. We're doing chapters 1, 2, and 9. And I am open to maybe seeing if, Mr. Hardy, if you'd like to kind of give an overview as to how the process went, and then if there are any key items that anyone had flagged, we could go about it that way.
Sure. When the board decided to undertake a policy review, which frankly has not happened in many years and is not an easy or quick job, but probably a very useful one for everyone, I began looking at the policies and then interacting with various staff members. The superintendent, the 3 assistant superintendents were each assigned various chapters, and I met with all of them and at times over the past probably 6 months looking at various policies, and we're still in that process, although chapters 1 and 2, which were Dr. Bowden's, chapter 9, which was Mr. Lempy's, we have gone through. We interacted with other staff members as needed on particular policies. I made suggestions as to things I thought needed to be changed from a legal compliance standpoint. Laws change, obviously. As we know with the charter school one that we took kind of out of order, it's changed twice since we even looked at it. And there could be some other ones as we go through that we find that about, because this process started well before this legislative session. So then we would meet, I would meet with the various staff members, and they would also make some suggestions to make sure that either so that our policies and our procedures were in compliance by either suggesting a change to the policy or by changing what we actually do so that we're in compliance with those. And basically what you have before you is the product of that work, and that was a substantial amount of work by a number of people. Before it got here, as the board knows, each of you have also been assigned chapters. I believe Mrs. Brown had chapter 2, and Mrs. Zucker had 1 and 9. But we haven't gotten to that one yet, yes. But for today's, so I believe that they met with 1 and 2 with Dr. Bowden, 9 with Mr. Lempy, to also give their input, and so that they could be perhaps the most expert about those as this conversation starts. As far as how we proceed from here, obviously that's up to the board. My suggestion, and that's all it is, to you is to, rather than go through every one or every line, just to see you all have had a chance to look at things, and just to kind of start at the beginning. 1 is easy, there's only one policy,
right.
But 2 is obviously much more involved, and just see, you know, does anybody, the first one is 2.10, does anybody have any questions, comments, or concerns? And if not, then we just move on, because otherwise we will never get through chapters 2 and 9 in 2 hours. We may not anyway, but that's my suggestion for how we proceed. I don't know if Dr. Bowden has other thoughts about that.
No, so just the only point is we've set aside 2 hours today. It's highly likely that we will not get to the end of Chapter 9, but that will serve as our starting point if we gather here a month from now. Kind of one of our takeaways is as we move through this, it's our preference, certainly looking for direction from the board, but it is staff's preference that we move by chapter to bring these through the legal process. This is a review. The policy manual clearly belongs to the the board, but any changes, even if they're just legal in nature, have to go through the advertising process. And so based on the feedback that we get today, we would, before leaving, seek permission to bring these back on a future board item and advertise them on their first read with the public. And so having said that, I'm ready to go at your leisure.
So,
Go ahead.
so what you want to do is to do chapter 1 and chapter 2 in order?
Correct.
Okay, so I have 9 and it's ready.
Correct. Well, so in order means chapter 1, chapter 2, and then chapter 9. What I don't want to do is say, we're not sure about something, let's set that aside for a later date. If there's a discussion to be had about 2.5, let's have the discussion about 2.5 and stay in chronological order. But we can bring chapters in any order. The reason we didn't do 1, 2, and 3 is, quite honestly, Shirley said, 2 and 3 are really big. Can I spread mine out over more than 1 month? And so one of the things we'll have to decide is what's up next. I anticipate we'll get through 1 and 2 and partially through 9. And so we'll ask you for permission to bring changes, if any, to chapter 1 and certainly in chapter 2 to the board. We'll say we're going to pick up on chapter 9 a month from now. And where do you want to go next from there?
So in completion of a total chapter as opposed to piecemeal, so that way we
Correct.
can move the
Yes.
process forward. So
Right. I think the thought is we're going to have to advertise changes, just advertise all of chapter 2s at one time.
very good. Well, 1 is easy, starting point. So as I don't know if you had any comments or thoughts on 1.
No, 1 was so easy, it was a paragraph. But who's so common with 1?
Jane.
I would like to see vision and mission changed at some point. I think that we can do better.
I agree.
But we are looking at strategic plan at some point, and I would think that would be done at that time.
Well, and I agree. Actually, I marked on chapter 1 is it being a simple chapter, and we could potentially mark that done. But there is a continuity I think is important in any policy booklet, and so not to bounce around, but to reference chapter 2 does at the very beginning. 2.0 says the responsibilities and authority of the board, and then it lists the vision of the school board X, Y, and Z, and it doesn't match up to chapter 1. So I think it's important that when we determine the very specific language on the vision and mission, that be continuous throughout when referenced from a continuity standpoint. So, Jane, as it relates to the vision statement, did you have any, quite frankly, I know we worked on it at a retreat back in 2015, I believe, but I'm not sure that it's reflected here.
Well, since you asked for, I'm sorry, she asked you.
So either way. This is
Go ahead,
casual. It's only 3 of us. I think we certainly can,
I think we can talk.
can make
yeah.
it pretty conversational.
I think since what I'm hearing is you'd really like to look at the mission and vision and change it, I think we should just leave it alone, and then in the summer, when we do this, just revise it. Instead of sitting here now and trying to revise it with only 3 board members here.
Okay.
I would agree, and I think, a vision statement needs to be at 30,000 feet.
Right.
And a mission statement needs to be active and in the present tense. And so I think we should look at revising it later.
That's why
fine
we
for
did
now.
not do anything with that, because we did not want to change it, because the board would need to change it, not
Right.
one person.
And I can go back, or we can pull what was said. I know in 2015, like I said, we did pretty extensive discussion around that. And as a starting point, the easiest chapter we may not complete today, but to bring that in as a starting point, and then I suppose bring it forward and hopefully check that to move forward for advertisement and adoption.
The good news is it's 1 page, and we're not suggesting that we bring it forward and then bring it forward at a later date a second time. And so, because there are no proposed changes, there is no further board action on it until the board decides to make changes to the mission and vision itself.
The only element here that says on the notes, it says document requires annual school board approval, policy requires annual review. I know we talked about that. I don't believe that that's something we've been doing, and while I think that it's every year going to likely change potentially any chapter, do we want to strike that completely or keep it, but then we have to act on it?
My suggestion would be, if you want to defer on Chapter 1 on the mission and vision, come up with the new mission and vision whenever the board chooses to do that. And then I would suggest striking that. I don't know that you need to reapprove it every year. Obviously, when the board wants to change it, you just change it.
Okay.
I don't know that you have to necessarily review it every year.
I agree.
Okay, so that I will make note of. All right, moving to Chapter 2. What I had thought initially was, since each of us, I want to say, quote unquote, owned the review with members of staff after the legal review was done. I know Mrs. Brown isn't able to be here, so since for continuity circumstances, would you be opposed to jumping to 9 since you?
I'm ready.
And Jane, is that okay with you? Okay, so we're going to move to 9, so that any notes or thoughts that you had on that, since you are present, and we'll hold 2, depending on how far we get with 9.
If you look at 9.101, the last sentence in the first paragraph, we changed the schools and parents must work together as partners, not necessarily as knowledgeable partners, but as partners.
Can you tell me the page number again?
First page,
First page, okay.
and it's 9.101.
So there was a change to this? I don't see a
So the
track change.
first one is parent organizations and school support groups, 9.10, and there's nothing.
There's no track change.
there.
No proposed change to 9.10.
Okay.
Mrs. Zucker is referring to 9.101,
Right.
Right.
Okay,
where there's a proposed change in the last sentence of the first paragraph.
All right, so just let me ask you a legal question. You have changed some of the statutory authority and law implemented. Does that mean it needs to come back when we
I think it probably should. I think we probably need to, when we're doing Chapter 9, even if we're not making a change, I would suggest just redoing all of Chapter 9 so that whatever, if it's, June 1st, 2018, that's when they're readopted, all of them.
in completion as the chapter.
Yeah, that's
I agree.
what I would suggest.
And then they will all have a revision date of this summer. So we will
Correct.
know that this is done and completed
Correct.
going forward.
That's correct. Okay, so 9.101.
The last sentence must work together as partners, striking the word knowledgeable.
I have no issue there. I don't
So
think.
I don't want a parent who doesn't think they're knowledgeable not to work with us.
Okay.
The next is 9.20, and it has no proposed changes. Obviously, if someone wants to bring one up, please do.
Now, when I reviewed this again after the changes were made,
Okay.
The district strategic communication plan is in progress, correct?
correct?
9.21 is school reports, and there were no proposed changes to that.
Yeah.
And I'm not counting any kind of law stuff at the bottom as a change. I'm talking about substantively. 9.30 is use of facilities, and there are some changes. This is your policy on groups using the facilities.
Yep.
Part of this was, I think, to make it more readable. I hope it's all self-explanatory. The point is that it is, but if anyone has questions or concerns.
And in terms of content change, a lot of this was just kind of, as Mr. Hardy said, make it more readable, moving things around. So if you look, for example, at what appears to be a pretty significant change in sub 2A, we actually took that language out of sub 5 because it just seemed to make more sense in 2A. So it's word for word, it's just in a different place.
Okay.
So what appear to be two big changes, neither one is a change, it's just moving it from place to place.
On page 2, I found a typo.
where?
Under section
Oh, I got it.
4.
Or.
by the superintendent or their designee.
Just so
sent
credit
you
where
an
credit is due.
email.
So Caroline sent me an email Saturday at 1:53 in the afternoon pointing out that same typo.
Because, see, I did read this, Caroline.
So, yeah, I'm amazed.
And since we're changing this, and I agree, it probably should be or his, her designee as opposed to their.
Yes.
If we have an entity that has using our facility and they happen to have a political organization that is going to have a booth or be a part of an event that someone is holding there, are they allowed or not allowed to be there?
I think that, I know, is an issue that has come up recently, and I think that is policy 2.51, if I'm remembering the number correctly. And there are prohibitions for certain types of political activity in 2.51. And I believe what I would analogize it to would be the prohibition, obviously different, but the prohibition against alcohol on school grounds. And we don't let outside parties bring in alcohol. I think we would also hold them to those prohibitions. I know there's some discussion about that, and there are also exceptions in 2.51. This policy doesn't apply when, and if the board wants to entertain adding another exception, certainly we can. I figured that was something we might talk about.
Well,
I really, we have always, and I know we can make changes, but we have always stayed away from any political issues at any of our schools. So there's no signs, no badges you're allowed to wear, no handing out of literature, no signing of forms, petition forms, nothing. We've kept our schools non-political, and I really think that's the way it should be.
as it relates to keeping within the policies, I think, and I think we were all as board members emailed on the specific event down in Northport.
Yeah.
But for chapter purposes, 9 is more about the transactional aspect
Yes.
versus on what's allowed to take place. Is that an accurate statement?
Yep.
But I do want to address and that's 2.51, I believe. But just to keep us going, because I had the same question, I think this is, again, more on the transactional legality of usage versus what's allowed to take place at that time.
I already emailed them back.
So,
All right, so we've got the typo that we fixed in subparagraph 4. Anybody have any other suggestions, comments, or questions?
Not
You have
just
both changes?
his and her.
Yes,
Okay.
taking out of there to or his, her.
Got it,
Okay.
got it.
no, I didn't have any other marks. I had a lot more marks on chapter 2.
All right, then
Moving forward.
9.31, and this is primarily directed to the Equal Access Act. And the change here was taking out secondary school and putting in various places middle and high school because there has been litigation over what is a secondary school.
Okay.
That is a
I had
less than clear word
definition.
under Florida law.
And we removed the references to elementary as well.
Right.
So should we be careful when using the term secondary?
Well, for purposes of the Equal Access Act, I know there was litigation in one of the counties north of us. I'm thinking maybe Marion, but that may not be right. But one of the counties, and the trial court found that middle schools were not secondary schools, and the 11th Circuit found that they were. So, perhaps that's now settled, but I thought it was best not to even wade into that and just make it explicit. Now, if we ever go back to the way it was when I was a child and we have junior high schools, then we may need to revamp it all. But I haven't heard that discussion, so hopefully we can stick with middle and high schools for a while.
I think we've evolved past that.
Okay. Showing my age.
Caroline, did you have a?
No, I just was going to, I see. I jumped in and started to do it, but Art's going to do it.
Oh,
So
I'm sorry, I didn't
Oh,
mean
no,
to-
no,
No.
you're keeping us, we're moving along.
Go right
I'm fine
ahead.
with that. I had a question on paragraph 5, chapter 2, 9.31. So as it relates to while acting in their official capacity, employees or agents of the school or school board may be present at meetings only in a non-participatory capacity. Was that changed statutorily, or is that more procedural?
No, that is a change statutorily with regard to something that changed last year, the Florida Student and School Personnel Religious Liberties Act, which is 1002.206, which is the new reason I was able to find it so fast was because we added that in.
Correct.
Here under laws implemented, and that changed or clarified, I suppose, depending on your position on it, the law on when staff members can participate. And under that law, the legislature said staff members may participate, but the equal access law says they can't when they're working as agents of the school. So we're frankly trying to thread the line there to make clear that under the Florida statute, yes, staff members may participate, but we're making clear under the federal law, not while they're acting in their official capacity.
So you're referring, is it the Religious Liberties Act from last?
Right, from last legislative session, 2017. So that's why we added the phrase, while acting in their official capacities, meaning they're the sponsor of the club, let's say.
Okay.
Or they're there, even if they're not the sponsor, if they're there to keep order, as opposed to they're just
Leading it.
a third party who's joining.
Okay.
Because let me see. I know that the law included a provision allowing staff members to participate. I just wanted it to be clear, because under the Equal Access Act, it's also pretty clear that as agents of the schools, they cannot participate.
So they can provide oversight vis-a-vis safety, et cetera.
No, people in there, yes, there can absolutely be an assigned sponsor of the club, but that sponsor is there, in essence, to keep order, not to participate in the club.
Okay. I just
But
wanted-
that would be somebody working in their official capacity.
Okay. Okay. Welcome, Eric. We're on 9.31.
Thank you, Chair Ziegler.
Okay, that was the only marker I had for that, just for clarity.
Anything else on 9.31 then?
9.31, item 7. We currently, in our organizational chart, have both an executive director of middle and an executive director of high school. But one of the things that we proposed and was accepted on our 1% reductions at the district office was to move to an executive director of secondary schools and not replace the executive director of middle schools. And so this change would run contradictory to that. So we were in the right place. You moved it to where we currently are, and we need to go back to where we started.
Okay.
Which means reintroducing
You
the
ruined
second
my
word.
purpose.
Well, we can, I don't see that as a problem, because that's an individual on our org chart, as
Right.
opposed to trying to say what our schools are.
Or is there a better way that every time we make an organizational change that we don't have to make a corresponding policy change? Can we say the
Appropriate executive director?
Yes, so that we don't have to continue to go in and change one. I think I just stole Eric's. That was
Well, can we get the copy of that new org chart?
because I know how much you love your org charts. But yes,
I
at our
like
next
org
workshop,
charts.
we're going to show you some org charts. I'll make sure yours is in color.
And they're just
Yeah, I think it probably makes sense to, since we didn't even get to the advertising and we're changing it, probably the appropriate executive director,
and then just line out the rest of that.
or let's see, it says
What would
may
that
be
be?
appealed to the appropriate executive director, period.
Yes, that's where I am too.
Who decides who the appropriate executive director is? Indeed,
That's what I was going to say. Who does that? That's
Well, I mean, we're talking about middle and high school students, so it would be the executive director who
overseas.
oversees middle and high schools.
You want to say that?
Or is it appropriate to have the superintendent designee?
Because you think that somebody in elementary school is going to say, no, it should be the executive director of high school, not the
Never
executive director of
know.
elementary.
Policy has to be broad but effective.
Well, we could say we could put in appeal to the superintendent or his or her designee,
That's
and then you can send it to whomever you
Always
wish.
That just opens up.
well, and I think that's consistent with other ways in which you appoint. I mean, the superintendent's designee is an appointment, identifying. Are you okay with that?
I want to hear, Todd, were you okay with that?
Yes.
Okay.
All right, so we'll just appeal to the superintendent or his or her designee, period.
Okay.
And that'll be the end of that sentence. Okay?
Perfect.
9.40. And there were obviously more substantial changes here. I think these came largely from Mitzi and the finance department.
And me.
Well, yeah, the very first one came from our review with Ms. Zucker.
The red.
The red, yes. And we wrote it specifically to be flexible as statute changes relative to what's okay and what's not okay relative to advertising on a bus. So over time, it has changed from prohibited to can't be on the outside of the bus. And so this gives us the opportunity to just kind of not have to change the policy if and when statute relative to advertising on buses changes.
Eric?
And I realize that we have the ability to restrict advertising. Sure. Yes, advertising, no advertising. But once we allow advertising, restricting based upon content, it's my understanding, becomes a little bit more difficult.
Becomes more difficult, but clearly you can still restrict certain broad category. I mean, you could restrict liquor. You could restrict pornography.
What about
Okay, would you
controversial stuff like Planned Parenthood or
I think-
NRA, or I'm picking
think-
people on both sides just to
I
be
think
fair.
it becomes more difficult but the key there, I think, is that any restriction has to be viewpoint neutral. So you can restrict categories of things. You can't restrict half a category of something.
But we already have that with the signs that are all on our school fences.
Right.
I mean,
right.
or at baseball games or football games.
The specific issue with buses from years ago, there was a discussion of this was a way to raise revenue potentially. And I believe there were the law is that you cannot have any advertising on the outside of the buses. You can have advertising legally on the inside of like on many city buses or metros or what have you. You can do that. And I know some districts, at least at one point in time, this is probably now 8 or 10 years ago, we're looking into doing that. We had a conversation about that, and the board decided they did not want.
A board member.
Yeah.
Okay.
It was not us.
Okay, did not want that. But as I understand the proposed change from Mrs. Zucker, it's not allowing any advertising. It's just saying it may be permitted if it's allowed by law and with the consent of the school board.
Correct.
So it's giving you the option, but you'd have to come back later to say you want to do it.
But being able to say no to, first of all, for the most part, the ones around the football field and the ones outside the school are done through third-party
Local.
organizations,
Right.
PTOs, the boosters. Those aren't actually. I assume this would be done actually by the school district. We wouldn't sub this out.
I assume it would be,
I
yes.
assume it. And I'm just worried about a can of worms of content. You know, you could have also youth. I could envision also youth trying to put something in. I could envision NRA putting something in after everything that happened. I can envision a lot of people putting advertisements that make everybody, make certain people,
From a speech standpoint, from a challenge based on speech, the cleanest thing to do is just to prohibit it. But that's not to say that's not to say you can't have it other ways.
Well, right, baseline, but we can add to it saying we don't allow it at all, or more probably in a procedural standpoint, similar to third-party organizations coming to speak at a school goes through an approval process through the principal, I believe, currently.
And that's a significant point that I didn't want to get too far away from Eric's comment, is that once you approve the policy, it typically does not come back before you. And so if the NRA wished to buy signage at the Venice High School football field, that would be Eric Jackson's decision whether to accept or decline that signage. And you may get a different decision at one high school versus another. I will tell you, we had significant debate a couple of years ago about Daiquiri Deck wanting to participate with some of the signage at school sites. Daiquiri Deck is a very similar business to Gecko's, but because the name Daiquiri appeared in their name, there was some debate as to whether we wanted to, if that signage was appropriate at an elementary, middle, or high school. Ultimately, based on this policy, we left that decision to our cost center heads. So I think you made a comment that it would come back to the board. It would not come back to the board. That's why the policy is so important in providing that guidance.
Well, as it's written, it does come back to the board.
Not in item 6, it doesn't.
With the consent of the school board.
No, in the red, at least in my version, it's red. In the first paragraph, it says, advertising on or in school buses may be permitted as allowed by law and with the written consent of the school.
Oh, I was taking a much more, I thought we had moved on to a discussion about banners and drop-off and pickup lines. I wasn't specific to buses.
No, we were still on buses.
Well, I
Isn't as a comparison, the analogy isn't clean with the banners because it's a booster club versus the actual school board. I'm just saying that analogy isn't exactly apples to apples.
Right.
Well, as far as school buses specifically, I think that what we allow for outside exterior chain link fence, whether third party or not, should be consistent with what would be approved on a school bus or anything else. Is that from a process or policy standpoint? I mean, I think that makes it more sense than having it's one thing over here and another thing over here. I think that's where you get into whether people, one, are aware of it, and two, are
Well, one issue, obviously this is the board's policy. You can make the policy decision. One issue that came up years ago when this was being discussed as far as advertisements inside school buses was the thought that you had captives, that students were in the bus and, if it's one thing if it's on the outside of a fence and you see it when you're driving by. It's another thing if it's on the inside of the bus.
Okay, no, that makes more sense.
But that may be a distinction without a difference, but that was at least part of the conversation.
Good.
And the banners are school by school. The principal, like I said, Eric Jackson would do Venice. The buses would not be school by school. It would be a district-wide policy. So,
Very good point.
So it's not a clean analogy.
So, okay, good point. I'm okay with it with the written consent of the school board, right? This gives the authority. I mean,
I am not.
you are not okay with that.
No, because what do you do when somebody comes up and wants to do the NRA? I mean, I'm saying this because I'm pro-NRA. My wife's a member of the NRA, but I'm just taking somebody that I wouldn't be. When the NRA comes and you're going to tell them no?
Yeah.
That's upon the board to make that decision.
And then when the anti-gun people come and you say yes, we're going to get sued.
Well,
That's a good point.
that would be problematic.
That's a good
Yes.
point. No.
Because you need wherever it is,
Continuity.
you need to be viewpoint neutral. You can take out categories of things, like you can say no liquor ads.
Right.
But you couldn't say,
No country.
well, except for vodka
No.
or except for beer, because beer is not as bad as hard liquor, or, you have to say no liquor ads,
So there'll be no gun
for
ads.
example.
So the question is, do we want to allow advertising inside or on buses or no? Period.
I just think it opened a can of worms. That's my own personal.
Well, to me, since it's in law, it should be in our policy.
Law,
Well, law does not prohibit, law says you can't have it on the outside of buses. It does not regulate
inside.
the inside of buses, at least as of several years ago. I haven't looked again, but I'm not aware that that's changed. So that gives the board the option to allow it or not allow it. So you have,
Well, some school districts
flexibility.
are making money on this,
Yep.
and they've found
believe
that
that's
they
true.
need to do that since we're getting 47 cents a student or less. So I think there will be more opportunities. That the main key to me is that viewpoint neutral. That is a big thing, and that needs to be, front and center on anything that we do. And I think that's the big one.
Maybe what we should say, written consent of the board and be viewpoint neutral.
I think it needs to be somewhere in this policy that it's viewpoint neutral.
Well,
Our denial has to
right. Your decision-making or your rules
Yeah.
have to be viewpoint neutral.
But I think that needs to be in the policy, is what I'm saying.
I'm glad we're having this discussion, just because now that you think about it, and inside the bus does concern me, especially if it is. I understand it can be a revenue opportunity, but that's a slippery slope.
Well, it is.
Viewpoint neutral is also challenging because
How do you say no to the NRA?
No,
Very easy, no.
Because you don't agree with their viewpoint.
well, not necessarily.
It doesn't matter. If I thought it was wrong for kids, I could say no to anything.
But that's where we get into an exposure, unnecessary exposure, I suppose.
Did you say yes to Planned Parenthood?
No?
Go down the list.
Well, what if it's Gatorade? I mean, you can use something else that's, just a product that certain families may not support the usage of, and they don't want their, right? I know this, this is going...
This is like ridiculous.
No, actually, no. I think it's to avoid issues and avoid exposure. I
If
actually
you don't
think...
want it in there, take it out.
Yeah, I think
I'm
leaving...
not married to it.
We've had issues at Pineview with classrooms that have collected Coke or soda, or whatever you choose to call it, and just stored it in the back of the room, not to drink it, but for a carnival or something that they were having, and parents getting upset because it was in the room with their students.
But, that's exactly right. So we could end up being... So if we just don't allow it, we avoid that circumstance. Yeah?
Fine.
So advertising on
take
and
it out.
in school buses shall be prohibited?
So if you look what was struck, the policy initially read, advertising on school buses shall be prohibited, period. If what you want to do is just leave the policy that way, I think that's what I'm hearing.
Yeah.
Yeah.
We just remove our change and go back to the way it reads today.
Yeah, I'm fine.
I just remember the fight in trying to get that passed.
I think it was a good thought, Caroline. I like making money.
So then everything to follow it would not be included because we're not allowing it. So all of that's stricken. Correct?
No, just that red is stricken.
Right.
The rest is not specific about buses.
Okay. Okay. Okay.
Anything else on 9.4 to discuss?
Not that I had marked. Anyone else?
No, nothing more.
Items 7, 8, and 9, real quick, are all added. And I know you and I talked about that. I wanted to just clarify if that was an add-on by statute, or is it to line up with current practices?
What about 9.5? Oh, is there any changes in there?
Or are we,
I'm sorry, I'm at 9.
you're still on 9.40?
Oh, we didn't move off of there. Okay.
The additions, I just want clarity on that being added
Okay.
by staff. Not
I don't think that's necessarily from a statute. I think that was just viewed to be good practice. And I don't know if that came from staff, and I think it may have come from looking at other policies
Okay.
from other districts.
Do you know? Caroline, do you know if there was any additional discussion on that?
No, we had no discussion on it.
Right.
I think 7 is to kind of clarify some of the things I was talking about making sure there was an exclusion
Right.
for drugs and pornography, et cetera.
Yeah, we did too. No, she was. No, we didn't.
Okay, yeah, I'm fine.
Supreme Court does.
I just wanted clarity. Okay. Moving to 9.50.
There, we just made a small addition because we talked about district-wide distribution, but not school-wide distribution, so we just clarified that. Pretty simple policy.
I'm done. Okay.
All right. 9.60, visitors.
Because of the changes that we're doing facility-wide from a security standpoint, is there anything, was that taken into effect?
Yes.
Okay.
And I think you will see, a policy, what Mike has been referring to as VIMS, the Visitor Identification Management System. I think you'll see that as a policy that will talk much more specifically about what the arrival experience for a visitor looks like. But in terms of this policy, Caroline's right, that was consistent with what we're doing today.
And would that policy be added to not Chapter 9? What Michael?
That would not rise to the level of a policy.
Right,
That
it
would
would
be a
not.
procedure.
Yes.
Okay.
Yep.
Well, I think it's being, at least some of it is referenced in policy 3.40, I believe.
But the VIMS in its entirety is not
Not the whole, right,
policy.
right.
Okay.
But I think there will be another policy that you see that has something to do with access.
And I
believe that's-
brought a copy of 3.40 in case anybody wanted to look at it, but the title of that policy is Campus Disorder and Trespass. But it talks about arriving on a campus and what you need to do in 3.4. If anybody cares, I have a...
No, let's take them in
Highlight.
order.
Okay. That was my only question on that, just to make sure that it's broad enough
Yeah,
to,
I think so.
as we evolve with our security procedures.
Okay, 9.70, no changes are being recommended there.
Okay. I don't have any notes.
Okay. 9.75, community service. And the changes here, I think, are designed to bring our policy in line with our experience, what we're actually doing.
Yeah, these mostly came from Sue Meckler. We asked her to kind of look at this and make sure that it's consistent with what the current rules are. So this just makes us compliant with the current community service rules.
Okay. Shirley?
So we only have the program for the scholarships created by the Florida legislature. We don't work it for anything else? Like if other schools want community service, we don't have to have a program designed for that?
Are you making reference to a specific?
Well, it says right here, it said, or other scholarship programs, and we're taking out other scholarship programs and putting in created by the Florida legislature.
I think the thought there was it originally read the Florida Academic Scholars Award or other scholarship programs. So I think the thought of that was it was scholarship programs from the legislature, because that's where the Florida Academic Scholars, I believe, came from.
Right.
So we tried to make it broad, so it's whatever it's called, whatever the legislature does. If there are other scholarship programs out there from the community or colleges or what have you, that doesn't mean kids can't do it, students can't do it, and we would presumably assist with that, but we're not going to develop a specific program because X university says we would like to see this.
Okay, thank you. Just wanted to clarify.
And then most of what's stricken in 4, it's because it's so specific, and that doesn't really apply anymore, and we tried to make it more general.
Okay.
So if no one has anything else, then you can all congratulate yourself on
One
knocking a chapter down.
Good job, Caroline.
Thank you.
So Chapter 1 will not need board approval, but Chapter 9, with your consent, will appear on the May 15th board agenda for advertisement.
Sure.
Which means,
Congratulations, one down.
I'm just thinking about the timeline. So we have agenda review the day after tomorrow. So we can probably have, when whoever said work at the very front of this is my policy binder. This has been a labor-intensive process. I'm just thinking about the timeline. We can have a motion for sure in time for agenda review on Thursday, as long as the policy changes, and they're minor, what's happened today, but I want to make sure that Mr. Hardy and I have a chance to just compare notes and make the changes, and that all happens in my office. We can do that pretty quickly, but Just, I guess for you, Dr. Bowden, mostly when we go to a agenda review, the attachments may not be there Thursday afternoon, but they'll certainly be there by the end of the week.
Gotcha.
If that's okay.
Fine with it?
Yep.
Okay. One chapter down. So then going to 2, although, and I wanted to just, well, I may want to wait a minute just for Shirley, since I know that's the one that she oversaw. And my thought, again, unless there was anything you wanted to jump to, but I liked the way just going consistently through it. Were there any items that jumped out? So I'm going to give her 1 second. And Shirley, just to recap what I'd mentioned was, since each board member had various chapters that they quote unquote owned or oversaw, we started with 9, and then now that we're over to 2, I didn't know if there were, as we go along, if there were any items that stood out to you for changes.
I appreciate that. And I appreciate you holding it for me.
So
Apologize for arriving late.
No problem. We got 1 chapter done. So 2.10.
2.10, and Dr. Bowden was the one who had responsibility for this, so I don't know if you want to lead the going through, or?
I'm happy to answer any questions. I believe the first one was just a legal cleanup.
Okay.
Yeah, that's coming out of the statute, that verbiage.
No. I'll just speak. I mean, we'll keep going.
Okay.
Sure. Silence is golden.
211, 2.11. There's no changes.
Statutory reference.
Statutory reference changes. Yeah, I'm sorry, wasn't here.
No worries.
Is somebody else saying what these are, or am I supposed to say what?
No.
Actually, Art's done an impeccable job at kind of walking us through.
Yeah, I would like Art to do it, since
Okay,
he
I will
looked at
just-
them all over with the League of Mind and
Yep.
the statute books in front of him.
And so what we discussed very briefly, Shirley, at the beginning was we're going to try to get as far as we get in our time. For example, we just got done with Chapter 9. We will have all of Chapter 9, whether it's being changed or not, back on the agenda, so that all of Chapter 9 will have a date from probably the first meeting or the second meeting in June, when it gets ultimately approved. So, all right, so 2.11, no.
Yeah, 2.11, my only point was the notes. Policy requires annual review every 2 years or dates of newly elected board members. Again, kind of going back to what we started with 1.0,
Take it out.
striking it.
Probably should just come out.
Yep.
Any board member at any time should know they can bring forward a policy for review outside of, okay.
Sure. 2.20,
I have a question on here.
okay.
We're allowed to call in. If there's a quorum, we're still allowed to call in, and I didn't see that in here.
Yeah, I believe that's the longer 2.22. I'm pretty sure that's in there. I know it's somewhere.
It is. It's on page 3 or 4. Third paragraph B, 5.
Under the governance.
Yeah, and that's what your note says, Art. There's a note here that says, do you have the comment on the version you're looking at?
Yes.
Is it was moved to 2.2?
Moved to 2.22.
Yeah, it appears as if it's struck. It's not been struck. It's just been moved.
Okay, thank you.
And I'll point that out to you when we get to 2.22.
And my only highlight on this one was just the vision, again, making sure we line it up, which may be a bit of a challenge if we haven't determined our amended version of the mission and vision. That's my, I'm sorry, 2.20 says the vision of the school board is to be a high-functioning, effective team dedicated to providing governance and leadership to the Sarasota County School District. I have no issue with those language, but I just think it should match 1.0.
Which is not, interestingly,
What
the
1.0?
vision in 1.10 right now.
That was my point, so.
So let me ask the question, why does the vision appear in 2 different places in the same policy book?
Don't know that it needs to be here.
Why don't we strike it from here so that when we revise 1, then the policy book is updated?
I'm fine with that.
That makes
I just
sense.
wanted the consistency. Okay.
And obviously, we took out that last sentence there because there was a period of time when the board had to set its own salaries, but it no longer does.
No, as a matter of fact, we set our salaries lower because we did not want to be higher than a beginning teacher at that time, remember?
So that's not
Now
something you
they're-
have to do anymore, so we just took it out of the,
You don't remember
policy.
that? That's because I'm ancient.
2.21, just struck the other officers. I'm not aware that we've ever had other officers.
Okay.
Would you like to be our Sergeant at Arms, Eric?
All right, 2.22. This is the longer board meetings statute. You can see the changes that were made, and I would point out a couple of changes. On 5, which is a new paragraph, that was straight out of the statute that was approved, I think now maybe 2 years ago now, that it makes clear the public has a right to speak before action is taken. That's the inclusion of Roman numeral 5. Roman numeral, well, hang on a minute, yeah? Yep, that didn't, we added a 5 and that didn't renumber the other one, so we'll need to deal with that. So 5 becomes 6 and so on page 3. But Caroline, what's listed there on page 3 is 5, which should be 6. That's where we moved it. If a quorum is physically present, a school board member may participate through the use of technology.
Okay, it's just was weird to me that it's here and not here.
And not
On
where?
the first page. No, wait, on the other one. Where have I told you before?
Well, we were in 2.20 before.
What we're trying to do is not repeat things in more than one place, but to put them in the place that seems to be the more.
Yeah, because 2.20 is about, it's entitled at least, responsibilities and authority of board. And that didn't really seem to be a responsibility or authority, but it is about the conduct of the meeting. That's why it got moved to 2.22.
Okay.
Okay, Eric.
And so I just want to make sure the one on 5.5 or the new 6 or whatever you want to call it, the last sentence. So that's okay with the AG? We can do that?
I believe that it is. A quorum has to be physically present.
But then they can participate.
Then they can participate.
They can participate and they can vote. And
Yeah, I mean,
Okay.
if you don't have it, the board could vote each time to decide there was a need for the person.
As long as we're allowed
as
to
long
do
as
it.
it's in your policy, I think.
okay, as long as we're allowed to do it, that's all.
Yeah.
So at the beginning of 2.22, we struck all informal meetings and conferences involving school board members.
I don't know what informal meetings
yeah,
and
that's what
conferences
that's why I had-
involving
what
school
does
board
that-
members are, which is why I suggested striking.
Okay, I'm fine with that. That struck me as okay. And on 2.221, provide that each member is notified by letter or distribution of the minutes showing a record of the change. Letter, I mean, I'm trying to, you don't want to make it the email, I mean, I want it broad, but in written format, just letter just seems, I'm probably very picky here, but do you know what I'm talking about, Art?
I do. I'm looking. I honestly don't remember exactly what the statute says on that, so I was just going back, although that was in.
Yeah, and 2.221 before, it just says a regular meeting date may be changed by school board action at any previous meeting, provided that each member is notified by letter or distribution of the minutes showing a record of the change.
I don't think we have
Just say notified.
It says or.
I would just say member is notified.
It says or distribution of the minutes. I mean, I think if we just say notified.
Yeah, I just. Okay.
Is notified, period.
Yes.
Okay.
Yeah, I think that makes sense.
Notified of the change, or I guess notified.
Notified.
Wow. Well,
Well, if you're
maybe we weren't
present.
at the meeting.
If you're-
Yeah, I was
yeah,
gonna say if you weren't at the meeting, that's what I was concerned. Is there?
There was a meeting, reason we changed that meeting, I didn't tell you.
Don't we have a policy, you snooze, you lose?
Yep, that's in here.
Policy 8 point something.
That's policy chapter 10.
And I would just point out on page 3, at the top of the page, what is now Roman numeral 5F. In talking with Dr. Bowden, I think we agreed F should come out, because I don't think that happens, and I'm not sure if it needs to happen or should happen. So I'm just pointing that out to you.
Okay.
Wait a minute. we're on
Unless
page
anybody
3.
wants Todd to answer your
Yeah, go for
emails and
it.
letters.
Didn't think it should be in the
Yeah.
policy. That's one that doesn't match up with practice at the moment, so.
I'm sorry to go back just section 4. Copies of the agenda for a special meeting shall be prepared at least 48 hours prior to such meeting. Fine with that. Once the agenda has been published, is that only pursuant to special meetings? That's my question. Once the agenda has been published, changes shall be made only for good cause as determined by the chair or a majority of the board. Is that the majority of the board would be at the current meeting? Because how else would we make changes?
Right, but I don't think that's just for special meetings.
Okay, that was my. So. That was the clarity there, because I don't know if we need to change it or not, but.
So can I just walk through a reality situation? We had something on the agenda, and the superintendent pulled it, says, it's not ready for prime time. But that wasn't voted on by the board. No, it probably should it, since he owns the agenda.
Well, I think the law on agendas is not entirely clear, but I believe it is that once the agenda is published, the 7 days in advance, it then becomes the agenda subject to the board chair being able to make changes to it, certainly at the request of the superintendent, but you don't have to do that. And that's why the superintendent, when there are additions and corrections, says that, and if somebody objected to that, then the board would have to make a determination
At the
whether
board
there was, and usually, frankly, I think that's one of those where no one objects, you now have kind of unanimous consent to do that.
So he still has a flexibility. I just want to make sure he still has the flexibility to pull an agenda item if he so wished.
Yes.
After
Correct.
publication.
But one thing it does preclude is me putting something on the agenda and try to, pull a fast one, not do it the night before, the day of.
Without
You can't
consent.
add something to the agenda
Correct.
after everything else has been published.
Without
The consent.
the chair
Yes.
allowing it or the board allowing it.
Right.
So, for example, if the chair did not want to allow it, you would then have to bring it forward.
Then the board could vote
At
to add it.
board. Okay.
Does that cover something to you?
No, we have a standing item on the agenda already.
For additions or corrections.
Yes, but that typically says it's specific to the consent agenda.
That's correct.
We might want to broaden that just on our standing agenda.
Right, that's correction.
Okay. I just wanted to make sure there was clarity and it wasn't
Right.
it was broad enough for a functional standpoint, and I wasn't sure if the specification was relating to special meetings or if we need to move that line. I mean, I'm fine with it right now. I
Okay.
just didn't know. Okay.
Anything else on 2.22?
When we talk about, I'm looking at 5C. We talk about that they're not making, I wonder if we should have some of that, because we do say something before the members of the public speak. Maybe what we say should be more in line with what this says. I don't know.
I thought the same thing, Shirley.
But this is what Bridget says.
No, it's a little different.
No, it's a little different.
Yeah, I mean, I think the whole purpose for me is that what we do here, and not just the board, but even from staff, it's in line with what's here and the continuity. So if that's what we agree on, that's fine to execute easily before public comment.
I would, because I think that what we tell the public should match what we say in our policy.
Correct.
So we might want to change that. But then if we do that, I mean, do we need to add that, the thing that we have about members of the audience having to, I don't know exactly what it is we say about members of the audience shouldn't be clapping or booing or...
And actually, that's a statutory reference, if I recall. Do you
Well, there's a statutory reference about,
clap?
in essence, how you remove someone, and you have to give them a warning first, and I believe that is covered in one of these policies somewhere, but
Well, I think maybe when we're talking about citizens speaking, and maybe that's something that, we
Well-
might want to look at and bring. I'm just thinking that it, and I'm sorry I didn't catch this sooner, or think about it. But I'm thinking it probably should be more in line with what we say to the members of the public that are speaking and sitting in the audience.
well, these are your policies for the school district, so I'm just thinking this through. Having a policy that says people in the audience can't clap, perhaps it should be, if you want to include that thought, it would be through the board chair shall inform, the
On appropriate content.
the congregation, before the hearing of citizens, the following.
Or, I don't know if so if somebody has to be removed, that's covered somewhere else?
I believe that it is.
Okay, well, maybe we'll just put a flag there. Maybe think about it.
I have it marked just to,
Yeah.
as we go through it, if it needs to be changed.
This is like, I don't know. If I were chair, I wouldn't want to be saying which are abusive, threatening, defamatory, obscene, profane, or otherwise. I mean, it's just.
The DVD thing, though, is good
Yeah,
because
the
sometimes we do have people who want to distribute or play a video or a clip of something, and I think that would be informational.
Well, or how about this? Rather than saying all this, we have a sign made and post it where we have the cards available.
I think there's value in speaking it sometimes, but
I believe your cards list some of these things
They do,
on it
yes.
that people
They do.
fill out.
They do. But what you're saying is it should be uniform, and right now it's not uniform. What you say and what's in here is not the same.
On the card, it says all speakers are to conduct themselves in a manner of which our students would be proud. Therefore, whether you agree or disagree, it doesn't.
That's what,
Maybe the cards need to be more specific. Not so much what you say to them, but what we say on the card. Because I think we need to tell them that, if they're going to be talking, it shouldn't be abusive, threatening, defamatory, obscene, or otherwise disorderly, or that can't play those things. Because we've had, in campaign season brings it out sometimes, we've had people come up here and say bad things to certain board members. We had one guy with a little hat on all the time that would come and, we've had a few people.
well, you get into a fine line of
First Amendment.
of people's First Amendment rights to come and speak. Obviously, they need to be talking about the business of the board. You can't come here and complain about, your zoning problem that you got with the county commission or something. It needs to be about the board, and it's certainly a fine line over what is appropriate commentary about an issue and what is abusive and historically we have relied on the board to use his or her judgment to try to redirect people if it was becoming personal.
We do say on here no CDs or DVDs, but we do not say that part about remarks that are irrelevant to the business or abusive or threatening. I just think
I think that
we might want to add that a little bit, and we don't need to do it in the policy, we can move on.
I was gonna say, I think that the policy is broad enough that it touches upon that, and that if we want to amend.
Yeah, we might want to change the cards.
Statement, it's going to be a cost to print all those cards with a new one, but I don't know how
Yeah,
many we
we
have
know.
left, but, but
Yeah,
certainly.
next time we print them.
If there were to be, I mean, because it's in the policy, even if it's not listed on the card or not listed by the chair's statements, and it were to be, someone would want to do that, and it would be denied, you reference the policy saying that we do not allow that, but I'm
You're
not,
going to have to keep that note at your desk.
or anyone who's the chair.
Okay.
Okay.
So, before you leave, I made a note because there are other boards. If you look at item, what is now 5B, have much more in-depth policies in that regard. In case there's 200 people that show up, they reduce it to 2 minutes, or they say no speakers past 10 p.m. We'll reconvene the next day. I mean, there's lots of
Or you can
more.
have 5 people speak on this subject.
Correct. And so this, I just didn't want it to go without passing, that if you're comfortable with this policy, understand it limits you, and the way it's written is per topic. And so if someone wanted multiple 3-minute slots, this would allow it, although that's not currently our practice. And so I'm not recommending a change, but I just didn't want this one to go without at least some discussion, as if it's the will of the board to.
You get 3 minutes, period.
How could we, that's a good point. I mean, I think that we should strike on a topic. I think that I don't want to, because it's different circumstances I'm familiar with. I think Hillsborough has a very in-depth 45-minute block for public comment. It prioritizes if it's to speak on the specified items of the agenda of the day. And and then if there's time, that's 5 minutes, and then 3 minutes if it's not on a specific agenda. I don't know if that's part of their policy. It must be. But if we want to go that granular, or if there's a way to write it where it's broad enough, and in the event,
I agree that the on a topic is a good
strike.
But on a topic means you don't come up and talk about 6 things, so you can look at it that way as well. You're not coming up to talk about
We have 3 minutes.
several different items in the 3 minutes, but you're only there to talk about one thing, and you're addressing the board, not the audience. So, that's, I think, where this sort of stems from.
Perhaps the B could say each speaker shall be allowed a maximum of 3 minutes to speak unless extended by the board.
Yeah.
The limitation, I know boards do a limitation of time. There's going to be 30 minutes for public comment. I know some of those some boards, and we used to many years ago, have 2 times for public comment. There was one time like we do now up front, and that was limited in time so that you could get to the business of the board, and then at the end there could be another block of time for public comment. All of those, my concern with that is all of those were before the law that passed a couple of years ago that said people must have an opportunity to speak before you vote, because before that, the Sunshine Law had been historically interpreted to mean people have a right to be present and to watch, but not necessarily to speak. Now the legislature has made pretty clear people also have a right to speak. So I've not seen any challenge to those policies based on that statute.
Oh, sorry. Go ahead.
I think we found some ways to handle when we had the transgender issue, and I think when we would work it out when you had a bunch of cards, we would call somebody up in line to be ready to go. So there were some ways to keep that moving. I mean, I think if we strike the on a topic, 'cause I don't care if they can speak on 6 topics. I mean,
Still got that 3 minutes.
They won't get much, but if that's what they want to, I mean, and we won't know until after they've spoken whether they spoke on 1 or 6 topics. So it's like, it's a cart before the horse. So I think it's a good strike to strike the on a topic so that the same speaker doesn't get to speak 7 times.
And I think that you don't want it too specific, that because where we run into a problem is if this is our normal way of practice and then we realize we have a large crowd and you change your practice, I think we'd be in a challenged circumstance. If we always handle it this way and then we change it today, that's not.
But
allowed
when we
to
had
speak.
the issue of
Unless we amend
the
rules.
history book or something, there were so many people filling it up, but by agreement, I think there were some. I think we ended up. It was almost like a hearing where we had them for side, and they sort of, some of them tried to agree that, these people are going to speak, and nobody was complaining. I think they agreed. I mean, we let everybody who wanted to speak, but when it came time to us making the decision, I think we had let them appoint somebody and gave them a time certain.
From a legal standpoint, if we typically have the 3 minutes, I like getting rid of the on the topic, but if there were to be any reason to amend it, the board would be able to, by a vote, amend.
You could, sure, you could suspend those rules. Particularly if people were all there to speak basically about the same subject, if that wasn't something you were intended to vote on at that board meeting, you could determine to, cut off public comment at some point, recognizing you're not voting on that issue at that day, and come back, either have a special meeting or at another meeting. People have to have the opportunity to speak before a vote is taken. It doesn't even have to be at the meeting. I mean, the law is clear. It doesn't have to be at the meeting where the vote is taken. It just has to be in advance of that.
Okay.
So that people can give their input before the board decides an issue.
So the way it is now is broad enough where we would have that flexibility.
I think so. I mean, obviously there would be criticism if the board were going to do that. There are other ways that I have seen boards try to recognize that we want to hear from people, is to say, please, we've got 100 cards. That means everybody's going to be here for many, many hours. Otherwise, can we have a few people speak on a topic and then people who agree with that view stand up, so we can see that however many people, agree with a particular view. You can't make people do that, but that's something that people sometimes are willing to do. They just want to make sure their point of view is registered.
Okay. So again.
But if the board wants me to look at how other boards handle that, I know the superintendent's right. There are policies out there that say we're having public comment for 30 minutes.
I don't think that's necessary. We have not gotten into problems. We really.
I agree. I get concerned with it being restricted in the policy.
Me too.
I think there's an opportunity, given circumstances, that the board at any given time can try to amend it to.
Board can also adjourn at any point.
Mm-hmm.
So, aside from on a topic, we leave it as is.
Yeah.
Okay.
Have we gone to 2.23? I think I was sleeping when we looked at this one.
Wait, are we done with?
We're on page 3.
Oh, we're still on 2.2? Okay.
Anything else on 2.22?
No, I think we actually already.
I'm not even on 2.
All right. Then I guess we're to 2.23.
Yeah.
I kind of would like to see a written explanation of why we're changing or adding or doing a policy, even if it's.
Where are you looking?
I'm looking at 2.23. Is that where we're at?
Yes, but yes.
We're under 1. We're striking, including a written explanation of the proposal. Or is it just obvious why we're doing it? I just sometimes see that we get something. Well, we used to get policy changes under consent agendas, new policies, and that was really one of my sticking points. I'm like, if it's a new policy, we probably ought to have it on new business and discuss it, so in case people, this was even before our superintendent was here.
That's required. That's required. I was going to say, I believe that's required by statute when it's a rule change, that it has to be on new business prior to
I think
For advertisement.
I think it has to be advertised. I don't know that it matters, as long as the board approves it. I don't know that it matters what part of the agenda you approve it on.
Yeah, we were saying
I
if
mean,
it
it
was
has
just
to be advertised.
if it was just a minor clean-
Including a written explanation it's not legally required, but you could certainly, it's in the policy.
Yeah,
So-
I would cross out written, because I wouldn't mind if we had a person standing there explaining why they were doing that, because I've tried to make it my habit to ask, why are we doing this?
So you're saying we should take out what we've taken out?
I'm saying we should put it back in and just strike written.
So you're saying to say, including an explanation of the proposal?
Yes.
Whatever the board desires. It's not, I mean, you certainly can have that.
Well, it still would have to be in writing the way the sentence would
Right,
read.
I was gonna say.
It would say, shall be presented in writing to the school board, including
Well,
an
that's again,
explanation of
in
the proposal.
writing, let's cross off in writing, because we're not writing things anymore.
Well,
Well,
no,
the
but
rule has
the
to be
rule would
in
be
The
in
rule is in writing.
Oh,
As
rule.
by way of an agenda, it would be in writing.
Right.
So that stands. It's just is including a written explanation of the proposal redundant at that point.
Well, I mean, any board member has the ability to request an explanation on any item, be it consent pulled for comment or new business. So if you required an explanation, that's certainly your right.
Well, I'm just wanting to make sure that the public gets an explanation if for some reason I'm not there. Because I'm sometimes the only one that asks. But if we want to strike that, we can strike it. But
It is your policy manual.
I'm asking for the good of the rest of the board.
I don't care either way, truthfully.
I think it's incumbent upon the relative respective board members to. But I'm fine. I mean, yeah, either way. So including an explanation of the proposal, that's broad, so it could be in a variety of ways.
Right. Just take writing.
Thank you.
Okay.
And change L to and.
I like the removal of substantially, because that's, how do you define that?
The rest of these changes are largely driven by statute.
Okay.
The whole appellate process, that's all coming straight out of the statute.
I didn't have any notes. Okay.
What's the difference between a rule and a policy? A lot of this is about a rule.
Well, pursuant to the first sentence here, there is no difference.
The same
Okay.
thing.
Historically, they have been called rules, and in the statute, it's known as rule making. We have called them policies, but we are saying they are
So
the
when we
same.
say policies,
That's the
when
same
it
as a
says
rule.
rule, it's our policy.
right.
So,
Yeah, the governing statute. Okay. Okay. So are we? So to 2.231.
all the other stuff we were striking is okay.
I believe all that was statutory is.
Look at this one. We didn't make any changes to this one.
All right.
So 2.231. Any comments? Keeping the same. Moving to 2.24.
Statutory reference.
Anything? Anyone? Okay. I didn't have anything. 2.25.
We really need to negotiate collective bargaining for
For the record, that was Eric Robinson.
These yeah, were adopted plans. We took off campaign for excellence because I don't know that we still do that every year. I don't know.
No, it really doesn't belong in there.
I guess that's why I had in my notes. Why list them all out? It must include, but not limited to. So all of the below.
There
Are
is not
currently
I
provided?
don't believe there is a legal obligation to have this policy. It is a policy that currently exists, and we chose just to take out some things that don't exist anymore, but I believe you could strike the entire policy if you wanted to, from a legal perspective.
I like it. I mean, it does, but it's may be adopted, so it's not any. I'm indifferent. I just, when you list out the
It's perhaps a
administrative
list
services,
somewhere.
the administrative services could change regularly, but again, that was my only question. And then the change to STC catalog because of the name. And then again, striking the policy review requires annual review.
Done.
Right.
That was my only mark. I don't mind it staying in here, but you guys all look so excited.
All right, 2.251. The only changes here was, well, one was a typo, and then the second was just a question. The board shall review annually the strategic plan. I don't know if that is something we do annually or not.
Well, I had written in here board annual retreat, whether we want to put that in a policy or not, if that makes it where it's consistent, where you're reviewing strategic plans. That was my only note, because I think that's important. I think that the strategic plan.
I think it's bigger than us. I think it's also, others in the district, so I think it's.
I don't think it's something that you can do annually.
No.
Because when you set a strategic plan, you set a roadmap.
Well, it's a review, so there are some are multi-year, some are. I don't disagree, but.
So I remember having this discussion with Lori White, and she said, you don't want to do that. You want to set a plan and then staff has to add to it. You can't do a one-year plan.
We just added to it every year for, I think, the last 20 years. And maybe 15. I know since 2010 we have not looked at it.
No, I think that's.
Every year Lori just added something to it. I think was more the consensus of the pillars. And
At some point, it does collapse under its own weight. It no longer becomes a document that guides the daily
Right.
practices of the district. And so
probably what happened.
that's part of the problem is it a collection of the work that's happening, or is it a document that guides the work? I would submit to you that our current strategic plan is just a collection of the work that we're doing, but it doesn't have the guiding principles.
Eric.
What I find frustrating is has to do with the improvement plans that we do for every school and we do for the district. It would be nice if we could see how did each school and how did the district do on their plan. I mean, we see these things where they say, I'm going to do X, I'm going to reduce suspension, and it'd be nice to know, well, did you achieve your goal?
You can see their plans.
You have to go, I do it. You have to go back and forth between the two and compare them to find out. It's not a very easy process to do.
As it's currently,
And that's
it's
only
an
if it
annual process, but it doesn't include last year's metric or last year's goal. So it says this year we had a 95% attendance rate. We want to increase by 1%. Well, it doesn't tell you that last year it was 93 and you went from 93 to 95.
And if they change
and we
goals,
populate the data. Most of those goals are driven because it's a template that comes to us by the state.
and not every school has the same goal, and so you could have a school that could say they want to do attendance, and in the next year their goal could be around suspension, and so you won't know whether they hit their attendance because in this year that's not one of the goals. So even then, that's kind of problematic to find out. But I would just like to know, this is your plan. How did you do on the plan? Is that unreasonable?
Well, it is a significant undertaking by the staff to complete the template as it currently exists. If there were flexibility within the template to have fewer goals, but to go more in depth. But the reason you have a template that is so cumbersome is they're all required elements by the state. And so essentially you would take an already very cumbersome process and double the workload because.
But what's the point of having a plan if you don't know you succeeded?
Oh, sorry. Do you want to respond? Or
Well, I mean, that activity takes place. It just isn't committed to writing in the template.
Shirley?
Do charter schools have to do these improvement plans, these cumbersome plans also?
Yes.
Or maybe we need to, maybe that's something we need to look at is to